In the tax man, he's a coming. 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 Yeah.
All right, hey, I'm just belting out some local.
I almost got him.
I was getting the high notes there. 1 second more, and you might have caught me, right?
Yep.
Saying it's July 3rd, 2017. Welcome to Let's Talk Native on the LTN Radio Network. This program breaks all the rules for Native radio. No buffalo speeches, no mystic healing, no special name prayers. A couple of high notes. We tackle the real issues facing Native people and look back at our glorious and our grave history, a tough look at where we're at now, and look forward to our ongoing battles for sovereignty and autonomy. Let's Talk Native is produced in association with Report Promotions on the LTN Radio Network, streaming live from the Cattaraugus Territory and simulcast on the Gwe, CKWE in Taindanega. You can find us with our live streaming audio at www.ltnradionet.com. You can find us on the Gwe in Taindanega as I speak. You can also hopefully if you catch us on Facebook, you're watching the Facebook live stream. We're finally getting down this Mevo camera thing a little bit.
It's looking pretty good.
Yeah, it looks good. The audio was sounding good, so we may be figuring this thing out. So. Welcome to the show. Hey, I'm John Kane, the show's host and producer. I've got Matt Hill on the board. I've got Ed Schindler here providing some of our commentary, and I've got Jake Proud behind the camera, behind two cameras actually. Not only is he keeping an eye on our Mevo camera, but he's also recording the video that will ultimately go on our YouTube channel, Let's Talk Native TV. Which is another opportunity to see a different perspective, see a little bit of post-produced version of the show. We never know when we're doing a live show. We never know exactly what's going to happen, and we're still getting our legs underneath us with the Mevo. So we're still figuring some of that out. But even in the worst case scenario, we end up having high quality video that gets put up on our YouTube channel by Jake, usually a day or two after our live broadcast. And of course, if you miss the live audio, we post everything that we do here on SoundCloud as well, so you can catch it later. And I encourage you to do that, but I also encourage you to share the video, share the audio, spread the word. Last week's show, I think we struck a note. Some of the feedback that I got from people really suggested, and even as we talked amongst ourselves, I know using a fancy expression like cognitive dissonance makes it sound like, oh yeah, we've really found a refined way to explain it. But the bottom line is, it may be a fancy term, but the whole idea of talking about the fact that we live in a constant state of conflict, a conflict that is one based on our core values as Native people, our identity, which has been challenged for hundreds of years. The facts of history, the fact that we have been victimized by the countries of Europe, by the United States, by their armies, by their citizenry, by their governments, by their courts, by their states. We have all of this history, and yet sometimes we do things that seem to be so complicit with the oppressive forces of the United States and the member states that it seems to disconnect. And I say that, as I mentioned last week, that can be associated with the way the religion that has been imposed upon us or incorporated into some of our lives, the enlistment in the armed forces, the use of courts, the use of elected officials, police, all of that stuff. I mean, child protective services, adoption agencies, all of these things that we look to the outside to use, knowing how mistreated by that same outside dominant society that we've been. And I think that show last week gave an indication about how a psychological theory not only explains much of the conflict that Native people have, but why that same psychological theory has, in many ways, a bigger consequence for us, not so much as individuals. I think these kind of, these problems weigh on individuals pretty much all the same, but it takes it another level because it weighs on us at the community level, at the family level, at the, in how it impacts us as a people, not just as individuals. So I think last week's show gave you an idea about how the conversations that we have here need to continue. And we're going to talk more on that subject as we go forward, but not today. Today, I want to talk specifically about and I want to say it's a court case, but it's not really a court case in the sense of a civil or criminal court. I want to talk about a hearing that took place and a process, which is it's called a petitioner's request. Back in 2012, we had one of the wholesalers here, ERW, who has been engaged, as many others have, in distributing and delivering Native branded cigarettes to other Native territories, or receiving them from other territories. I mean, we have a fairly well-established Native to Native trade, not only internally within the Seneca Nation or within Cattaraugus or between Cattaraugus and Allegheny, but even from territory to territory, and it's pretty well established. But in 2012, one of Eric's trucks got seized. A young guy by the name of Sean Snyder, a young man I've known since he was a little kid, literally. I mean, I've known this guy for a long time. He was driving the truck. They seized the Native branded cigarettes that were en route from one Native territory to another Native territory. They seized it, and then they issued them a fine. I mean, they fined ERW or the wholesaler, Native wholesale, Iroquois wholesaler, whatever the country company is, but they fined Sean Snyder, a young guy only in his 20s, $1.29 million. Yeah, so over $1 million they fined this young guy. And with no remorse. I mean, they didn't charge him with anything, no criminal charge, nothing. But they assessed a fine. So here's this young guy with $1.29 million hanging over his head from a very, very, I don't know. How do you describe New York State? I mean, not just an aggressive, but I don't know, almost a bullying mentality, an oppressive mentality. So he had this thing hanging over his head. Now I got asked by his legal counsel to give testimony in the hearings, and specifically what they wanted to talk about, because here was part of the problem. Part of the problem was that the state was arguing that not only do they have, were they trying to assess that they had all this authority to stop us from transporting unstamped cigarettes and all of that other stuff, which they don't, and I'll get into that a little bit as we go forward. But they also wanted to make the argument that Gunyonge doesn't qualify as a Native territory. In fact, what their argument was that it's not a reservation. So I was asked to come in and testify, and I was qualified as an expert witness to speak about Native history, including the history of Gunyonge. And so I went in. I got to talk about a lot more than just Gunyonge. But one of the things I made very clear is Gunyonge's existence, which was born out of a reclamation from the 1970s. The person who was representing the state in how they negotiated the terms to settle that reclamation, not to eliminate it, not to stop it, not to end it, but to how to make it peaceful and how to establish it in a way from a New York state side, how they could have the right paper trail to make Gunyonge work legally for the state. Frankly, our people could give a rat's ass about whether it worked for the state or not. I mean, it was land we were reclaiming. That's the attitude that our people took. So, and that's in the mid 70s. But the person who was representing the state was Mario Cuomo. He wasn't the governor yet. He was the lieutenant governor or something like that. So he was the guy who negotiated for the state to resolve not the conflict, but potential conflict going forward about a land that was reclaimed by Native people, by Mohawks in particular. What got established out of that was the community that was called Gunyonge in the 70s. It was the Gunyonge Project. That's what it was called. But the community still exists today, and it exists up near Plattsburgh, New York. And the land title has been held in a trust, and that was the way that the state was able to paper create their documents to make this thing work for them. But as far as the Mohawks are concerned, and as far as any of us in any of the other territories, it's a Native community. I mean, the state can call it what it wanted, but we never said it was a reservation. In fact, we don't even call these territories. We call these lands our lands. They're not reservations, lands reserved by the federal government for our use and enjoyment. Nor was Gunyonge. Gunyonge was a territory that was taken back. Now, how they squared away the title for the state's purpose is almost beside the point. So that's what I testified, and I explained what the Turtle Island Trust was, but then got into a broad conversation. And in fact, the judge seemed downright eager to learn more. I talked about the Atia case. I talked about the work. In fact, Matt, you and I were the ones who went to Albany and met up with guys like Dega and others. I think James was there when we met with George Maziarz and got 2 state senators to, and I helped draft the letter, but to sign a letter, not only asking the state for clarification on their policy towards native brands and native-to-native trade. But they went so far as to say, it's our understanding. We don't believe the state has the authority to interfere with native-to-native brands and native-to-native trade. And that's the position that Tim Kennedy, a state senator from the Democratic side, and George Maziarz, a state senator from the Republican side, they both joined together in signing this letter. And so I got to talk about all that stuff. I got to talk about the Maziarz Kennedy letter. I got to talk about the letter that came after that from the state taxation department called what we call the do not seize letter, which was from one of the taxing agents, a guy by the name of Peter Persampieri, who basically laid out how their agents were told not to seize product. And again, they made it clear that they weren't supposed to be seizing native product. That's by their own policy. And it wasn't a statute. It was their policy, their internal memos for their policy on how to deal with native people carrying unstamped cigarettes. And of course, what the state did here violated all that, including the fine that was assessed here. But I would say that my testimony here, and I'm not saying it won the case. I'm not going there, but one of the things that I was able to do as a witness, and again qualified and accepted by the state and the defense, I guess, as an expert witness, I got to enter some stuff onto the record that's never been in a court hearing before. I mean, so I got to address a lot of things, and the judge seemed very receptive to hearing what I had to say, not just about Gunyonge, but about how the whole nature of the tobacco business and when we got into specifically talking about Atia, and I don't know if I can pull it up here, but I've got an excerpt from the Atia case, which I think is the point that gets missed. And people talk about Atia, and now who was Atia? Atia was a New York State wholesaler. And what happened was, back when Mario Cuomo did indeed become the governor, he tried to stop his New York State wholesalers from selling us product without a tax stamp on it. And he was challenged, and he was challenged by the wholesalers themselves. And one of the wholesalers that challenged him was Atia. And what Atia said was, look, I'm not just a New York State wholesaler, a stamping agent for New York State. I'm also a federal Indian trader. I've gone to the Interior Department and I've applied for a trader's license. I have a federal license to conduct trade with Native people, and I've got some case law here that says that my status as a wholesaler to Native people, in that relationship, in those acts of commerce, that my status as a federal Indian trader supersedes state law trying to force me with another hat on as a New York State wholesaler to stamp that product. This went all the way to the Supreme Court. Ultimately, the Supreme Court ruled against the TIA, and it's kind of ironic because what the Supreme Court ruled was that because they could cite other examples out west, not here in our territories, not in the Haudenosaunee territory, but out in Colville Reservation, Potawatomi, or in Blackfoot territory, they were able to cite cases where the states were able to impose what they called a minimum burden on the tribes themselves to assist them in tax collection. So what the Supreme Court said, well, if you're merely a non-native wholesaler who's got a federal license, to suggest that you supersede state law because of your federal Indian trader's license, when we've got 3 cases that we can cite specifically where the tribes themselves didn't supersede state law, we can shoot holes in your position, and that's how they ruled against them. Now, again, part of the thing that I find disturbing is the territories that they cited as examples where the states could impose a minimum burden were certainly not territories like ours. They were territories where the state or the municipalities, the outside townships, provided all of the municipal services. These territories oftentimes had lands that were checkerboarded, and by checkerboarded I mean you couldn't tell from parcel to parcel as you drove down a road what was native held and what was non-native held, and that's all because of the way the Dawes Act and the allotment acts of the 50s and the 40s chopped up native territories. Our territories aren't like that. We have our own fire department. We have our water department. We take care of our trash ourselves. The roads are maintained by the state because the state, that's the obligation they have. But in terms of municipal services, and when you go on our territory, you cross a line. You leave New York State, and that's our position. You leave New York State when you enter our territories. In fact, we'd argue you leave the United States when you come to our territories. So that's the part that was disturbing. But that was the ruling. But even with that ruling, and again, they made a in the beginning of the case, and if you read this case, you can find the decision. You just look up the Atia case, and they make it very, very clear that the ruling was what was considered a facial challenge. We weren't in court. It was a non-native wholesaler that was in court. And they said, look, we're only making a ruling on whether this federal Indian trader's license supersedes state law. That's the only thing we're ruling here. Now, they did go into some description, and they did provide some commentary in the opinion, and the opinion was done by Justice Stevens, the affirming opinion, that is. And he made it very clear that, we get it. I mean, for the state to want to have their wholesalers pay the taxes up front on product that they deliver to our territories was a way of pre-collecting the tax from the wholesaler, which obviously the wholesaler would pass along to in the price to our territories, because the view that they had was it's really pre-collection of tax that the consumer, the non-native consumer, should have had to pay if they were buying it off territory. And and of course they tried to say, well, we're not going to tax the native consumer, only the sales to non-natives, which there was huge holes in the ruling on that. But one of the things I wanted to talk specifically, because they tried to justify that notion. And here's an excerpt. Here's a piece from the TIA, and it says, the specific kind of tax obligation that New York's regulations are designed to enforce, which falls on non-Indian purchasers of goods that are merely retailed on a reservation, stands on markedly different footing from a tax imposed directly on Indian traders, on enrolled tribal members or tribal organizations, or on value generated on the reservation by activities involving the tribes. Now let me break that down for you. What he's saying is, taxing a wholesaler for a product that he's going to deliver to us that we're going to turn around and sell to non-native consumers is different than them taxing us. That's what Justice Stevens said in this ruling. He said that's on markedly different ground than a tax imposed directly on an Indian trader. And Eric White is a trader of goods. That's what he does. He's a wholesaler. He's a distributor. So he is essentially a trader of goods, a native trader selling product from one territory. So they made it very clear that, for anybody who suggests that ATIA is a landmark decision allowing the state to tax this, that's not what it says. In fact, if anything, if you get into the details of the legal opinions expressed, they're saying, no, I mean, this is not a ruling that says you can tax. In fact, it says you can't. It's saying doing what the state was trying to do by making their wholesalers pay a tax in advance of making a sale to us is different than taxing us. Different than taxing us as traders, as people, as business people, as enrolled members, as what they said, or as a tribal organ like the nation itself. And also, it's different than trying to tax something, a product or service that we add value to, whether we manufacture it from soup to nuts or whether we simply add value to a product. Maybe it's a brand that we develop, even if we have it manufactured by somebody else. But if it's our brand, if it's something that we market and we distribute and we advertise and we promote, if we add value, we didn't add any value to a carton of Marlboros or Newports, but certainly you could clearly see on any of the native brands that were developed, no matter where they were at, whether anywhere on Turtle Island, we all of our territories, the wholesalers, the retailers, the distributors, they all played a role in adding value to that product, either through their marketing and that kind of stuff. So that's what the ATIA case really says. The ATIA case says that a product we're not saying that just because you can impose a tax on your wholesalers or on the consumers. I mean, and they're not saying that you can. They say, but that's a different place than taxing Native people. And so the whole idea of native to native trade is essentially almost protected in the language of ATIA. Now, I'm not saying it was granted, so don't get me wrong here. And so this part of this ruling, this opinion that Justice Stevens included in the ATIA ruling, where does it come from? Well, ironically, it comes from the same cases that he cited to overturn ATIA. Mo versus the Confederated Tribes of Blackfoot Nation, Colville, and Potawatomi. These are three signature cases, Indian country signature cases. But that language about value added, about taxing us directly, was from the same cases that the Supreme Court used to overturn ATIA in the first place. So it's not like this was pulled out of thin air. The federal government has been very, very clear, even with things like IGRA. We are not empowering the states to have either unfettered access or unlimited authority over Native peoples. So the courts have said that. Now, so the issue is that the states are not on the solid footing that they claim to stand on. Now, when you get into the ruling on this Sean Snyder case, what you find is that the judge says you're treating this wholesaler as if they're doing something illegal, and you don't have any basis of law to say that a Native person can't distribute they're a common carrier. The truck that Sean was driving was essentially, he was an employee of a wholesaler. They were delivering a Native product. It was all documented. This wasn't in the hollowed out back of a camper. This was in a commercial vehicle. This was, there was a bill of lading. There was an invoice. This was not being smuggled under the cover of darkness. This was a truck that was going down the road, going from one Native territory to another, from a Native wholesaler with a Native driver, with Native product, with a Native destination. And so the interesting thing is, getting back to the letter, Matt was one of the guys. He made the trip out with me to Albany when I met with George Maziarz, and ultimately stopped by Tim Kennedy's office as well to talk about this native to native trade. What they were asking, what the bulk of the letter, aside from stating their position as New York State senators, and their view on native trade. They were asking the tax department to essentially promulgate their policy. Tell us what your policy. Publish it. Let it be known. They said, for one thing, the people of the state of New York, and they weren't going to talk about us, but certainly the elected officials, who are the ones that create this legislation, say, you have an obligation to tell us what your policies are. What is the state's position on native trade? And Tom Maddox, who was the commissioner of the New York State Department of Taxation and Finance, refused to answer him. He refused to give him the answer. The closest thing to an answer we got was that do not seize letter that came, which was really an intercepted memo. I got that from John Crudell out of the New York Post, and that's how I got a copy of that letter in the first place. It wasn't made available to us. Somehow he had gotten a copy of this thing, and I distributed. There are wholesalers, including RW, who travel with both the Maziar's Kennedy letter and the Peter Persampieri letter from the tax department, because it's kind of clear that these, whether it's the state police doing a checkpoint or the border patrol or or taxing agents themselves, the policy was to not seize. The fact that this did get seized, and then they went and they went the bigger step of fining this kid at the time over $1 million. I mean, it was absurd. So I mean, to go through this process and again through this hearing and have a judge recognize the things that we were saying, recognize the shortcomings. In fact, not just the shortcomings of the state themselves, but the acknowledged shortcomings that even elected state officials, like 2 state senators from different parties, asking the question of the Cuomo administration, his tax department, what's your policy? And the fact that he refused. There's a thing about the law. It's not enough to pass a law. The people have to know what the law is. I mean, so there's this thing, the word promulgate is a fancy word, but what it literally means is you need to announce clearly and publicly. So to promulgate your position means to announce clearly and publicly what is your position. And Thomas Maddox from the tax department refused. So, and I explained this. I mean, I explained this to this judge, and she was able to check it out herself. And the bottom line is, it's impossible to assess a fine for something you're calling a crime where you won't even state for the record what your policy is. And to say, well, our policy is clear because we seized the product. No, that's backwards. You can't say, well, our policy is clear by your behavior. I mean, that's like shoot first, ask questions later, for crying out loud. That's moronic. And so I'm glad to see this judge having taken what I think is the proper position to tell the state, no, you can't do this thing. Now, and I want to be clear. I don't look to the state courts, the county courts, the federal courts as a place for us to win something. This wasn't something that we took the state to court. This was a situation where a young guy and Eric White with the ERW, they're facing the same thing, which obviously should go away because the same facts are related to their cases as with Sean's case. But the fact that I'm not suggesting we won, but clearly the state and the tax department lost because their own system looked at their flaws, looked at their inability to substantiate the authority that they were trying to assert, and said, no, you're wrong. And they canceled $1.29 million worth of fines. All right, hey, we're at the bottom of the hour, so let me go to a break here. Again, we opened up with the Taxman's Coming from Logan Stats. I thought it was an appropriate song. And what do we take the break here on?
I didn't follow the theme, but we got a little Teddy and Eddie.
All right, little Teddy and Eddie's good.
That's All Right, Mama, in Ganyakeheka.
All right, there we go. right, thanks for coming back. Let's Talk Native is sponsored by Roz and Holly John and the RJE Family of Business, by ERW. Eric White. And again, I'm not doing the show on their behalf. I'm saying that because it's news. But we are supported by Eric and ERW Enterprises, by individuals like Ed Schindler, Tracy Brown, Cynthia Trice, Scott Snyder, Neville Spring, Sugar Montour, and many others who have helped this program continue to educate, entertain, and inform for the last 7 years. We are in our 8th year of doing Let's Talk Native. I appreciate guys like Matt Hill, who've been a part of this show from, really from the very, very beginning. So it's great to have not only Matt sitting in to observe at first, but now you're running the damn board, for crying out loud.
Yeah, it just kind of grabs you,
So I certainly appreciate that.
It was back when you were in, what is that?
We still
Cheektowaga, what was it?
Yeah, when we were at the what was it called? I can't even think. Oh, the WEC.
Yeah,
the WECK. Yeah, that's when you were first sitting on. Yeah, that's where we started. Hey, look, I want to thank Unity Stream and Apache Radio Net for providing our streaming, the streaming for LTN radionet.com. I want to thank CKWE for simulcasting and for rebroadcasting the show. I know last night they rebroadcasted the Friday show, and I spoke with Darren Doreen, and he was really intrigued with the subject, and I think this whole idea of cognitive dissonance, the idea of us recognizing that our behavior isn't following our core values, is something that we have to reconcile. I think the lack of reconciling it is part of the reason we struggle with some of the stuff. But I had a great conversation with him, and I'm really thrilled that we have this relationship with CKWE. I also want to thank Netroots Radio, Real People's Media, and Indigenous Resistance Radio for carrying this program, for carrying the audio, and I want to thank all of you who share the links to the videos, the audios, and I encourage you to do that. I mean, I did a bit of a call out on my group page. My group page is called Let's Talk Native with John Kane. We've got over 7,000 group members, but you know what? With that many group members, it would only take about half of you guys to add a friend and push us up to 10,000 members. And if we had 10,000 members, it makes this conversation spread a lot more, especially if the people that you add as your friends are the kinds of people that would appreciate the information that's being provided here, and that would gravitate and maybe have some passion for Native issues. Whether they're Native or not isn't necessarily the only requirement. But I also encourage the 7,000 plus members of this group page to take a look at our YouTube channel, Let's Talk Native TV. Subscribe to it. You'll get notifications when we post new videos, and we're posting videos of the show, and we're finally getting our studio looking good enough that we can actually start shooting some videos. So we'll be doing some other shorter videos, and sometimes they're going to be just like a thumbnail sketch of some of the things we talk about over an hour, or for my show in New York that I stretch over 2 hours. And maybe just a 7 to 8 minute video talking about a specific subject, so you'll know where to find that topic, and they'll be labeled and categorized in such a way that you can find that stuff. We'll hashtag them so they're easy to find and that kind of stuff. So I want to tell you that. Now, thank you if you would take a look at that and become a subscriber to our YouTube channel. Now, I do want to give up the number. We do have a number that if you want to call in here, the number actually calls into CKWE in Tandanega, and then Darren Doreen patches you through to our soundboard here. It's the magic of electronics. But the number is 855-967-0463. That's the number to call to be a part of the show. I mean, we have plenty to say here, but we really do like hearing your commentary, and we look for it on our Facebook live streams. We look for your questions, your critiques, your suggestions, and if you want to call the show and offer something up live, we'd appreciate that you don't say the 7 dirty words, but we'd appreciate if you want to join the show. And again, the number is 855-967-0463. That's the number to call to join the show via CKWE in Tandanega. Look, you asked a question during the break, Ed, about whether this decision is reversible, and it isn't. right now, Sean is done. There's no fine. Now, Eric White and his company are still facing some of these same things. But it seems to me, unless something really, I don't know how, there's no new evidence. You know what I'm saying? I don't know how his aren't dismissed as well and thrown out. Now, and the reason they have to be thrown out, and as you read the ruling, you find that the judge is saying you've got no basis in law to suggest that you can discriminate and say, because what, this is a native company, that they can't be a common carrier carrying an unstamped. They were conducting a lawful commercial transaction to a place that can sell a product without a stamp on it. Now, so the question is, can this change? Well, the only thing you can change is if somehow New York State creates a body of law that authorizes them. But it's not just enough to create a body of law that authorizes them. It has to be legal. Not just pass law, but it has to stand up. So when I talked about guys like Martin Golden down there in Brooklyn, a state senator, Republican state senator, who was trying to change the New York State tax law and trying to put it on in their tax law that specifically native territories had to have a stamped product. It ignores the facts that I just read about ATIA in the first half of the show. He can't just say that all of the products stamped or on our territories has to be stamped, because it doesn't take into account the fact that product it's not Marlboro's. It isn't coming from a New York State wholesaler. It is coming from native trade. It's native product. It's the native product. I don't mean just native product because of the name on the product. It's manufactured by native people. It is part of our native to native trade. New York State can't all of a sudden try to they can, if they pass a law, it won't withstand even their own federal their federal requirements for asserting authority. It's not, it's kind of like the time that Len Violi from New York came up and talked to some of the folks here in Seneca Territory, and he said, look, as a lawyer, my job isn't to defend sovereignty. He said, my job is to find where state law or federal law is being inappropriately applied or misapplied, that it's being utilized wrong, that it's violating state constitution or it's violating the U.S. Constitution. His job is to find where laws are being inappropriately used. And clearly, I mean, I have a different view of where federal authority, where state authority is, based as a native person and based on sovereignty, based on our sovereignty pre-existing in New York State and the United States and colonial contact or European contact, all of that. A lawyer representing these guys is essentially going to say, where's your foundation of law that gives you the authority? And it doesn't exist. And so that's what some of these very high priced but very skilled lawyers, they're going to find the flaws. We hope. Unfortunately, they're limited in finding the flaws in state and federal law. Our arguments, and that's one of the things that if for people who bother to read ATIA, in that ATIA case, the government, the justices made it very clear. We didn't take into any consideration sovereignty. We weren't considering treaties. We weren't considering any of that stuff. We were just looking at the facial challenge and where there's examples in where there's precedents in U.S. law that they could either agree with ATIA or disagree with ATIA, and that's what they did. I mean, in fact, there's no place in there. I mean, and there's a reason there's not there. There's no place in there where they talk about native sovereignty. Why? Because once you use that expression, once a court has to acknowledge sovereignty, that's automatically, by definition, outside of their jurisdiction. They don't have the authority to weigh in on subjects that are outside of their purview. A court can only rule on where their bodies of law, where the Constitution. So people who may live outside the authority of the Constitution, or whose territories may exist outside the authority of the Constitution, that all automatically says this is not just a legal, this is a political issue.
That's why it's on us to keep asserting that.
Exactly. Exactly. I mean, what you guys did over your speeding ticket here was, it may seem like small things to somebody, because some people say, "Oh yeah, you got it dismissed." No, but what was very, very clear is when you called them out to say, "Where did you get the authority?" They could not lay the foundation for that, and that's why I say it's really important that when we do find ourselves in their lion's den, we have got to do a better job defending ourselves. It's not, because the first thing they want you to do, what's the first thing they asked you to do, Matt?
About what?
About your ticket, when you said you didn't, that you wanted to fight it. Plead guilty for parking illegally.
Yeah, they want to talk me down. They say, "Well, I'm going to do you a favor, basically. We're going to drop this down to a speeding ticket." I said, "No, that's not good."
So we're gonna have you plead guilty to a lesser offense.
Yep.
And that's you
try to make it sound real good. We're gonna, there's no,
we're gonna take
no
care
school,
of you.
no school. There's no.
We're gonna take care of you.
No points on your license.
Yeah. You still got to scratch off $150 because we're going to charge you for that, but we're going to take care of you. No, that's the crazy part.
Even when we got to the point of, he says, "You're not contesting that you're speeding." I said, "No," I said, "I'm not." I said, "But I am contesting under what laws I was being, because it was a nation resolution."
To set the speed limit.
It wasn't a state law.
Yeah, it's not even a state speed limit. Yeah. That's also the crazy part. But I think it's important that people realize that we need to know where the flaws are in their assertions of authority. We have to understand that where their limits are within their own laws. But we don't have to stop there.
It's not that hard. All you got to do is keep saying, that doesn't apply here. That's all you got to say.
Or show me how it applies.
Yeah.
Because I always say, put the shoe on the other foot. Put it back on them. Tell me where you obtained that authority. Mm-hmm. Because and this is the thing that I talk about all the time. There is no place in history where they can say that our sovereignty was yielded to.
In fact, that was basically how Ed was my expert testimony on that, and he explained the difference between a reservation and a territory, and how we were more in a solid standing because we were a territory and not a reservation. Because we were the original, we're still the original title holders to this.
Well, because essentially what you establish is that their authority never was over this land. And and that's where and I'm not saying that places that are called reservations can't make that same claim, but what happens is when you talk about the title of land, when you have people like in Mo, Colville, and Potawatomi, where the federal government says, "Well, yeah, but you guys don't really own that land. We're holding that land for you." So we, mean the federal government, we are holding your land for your use and enjoyment. Now, use and enjoyment is not the same thing as ownership and clear title. And although they're really hesitant to draw that distinction because it works against them in the long run, we aren't. And what we're saying to many native territories is, there was all this whole battle about, well, how do you take land that is what they call fee title, mean state fee title, and then put it into trust so it becomes Indian country. And that's what most of what the federal government calls Indian country is what they call trust lands. And we're saying, look, you went from fee to trust. Now you're going to need to go from trust to fee, but not state fee. And say, when I say fee, that is a definition of title. So when you go, if you've got land held in trust for you, at some point you need to take it out of federal trust and put it back into absolute title, your absolute title, because it makes a difference. And I think that's the argument we make. But I think it's really important that beyond land status, and some of that title issue, which I think is important, we have to assert that we as people, for one thing, we can't, within our own culture, we can't sell out the birthright of our children. When we talk about birthright is something that you're born with, and nobody. That's part of one of the reasons that in some of our old stories we talk about when somebody says, "Well, who holds the title to your land?" as well, future generations. Our women hold it for our future generations. Who owns this land? The future. That's what we say. Those children that are unborn. That's who owns the land. And I don't mean just our children, the children of creation. So what we're saying is the land, because we die. We're not going to live forever. So, it's almost an absurdity in philosophically to say that we who have a temporary presence here as individuals can hold title to land. Because invariably, the future generations are going to occupy this land when we're gone. So, for any people who say, well, those native people, they don't have the concept of land ownership. No, we have the concept. You don't. Because you don't understand the very nature of land and our temporary time to grace our mother here is something that we do, and part of all of life, the whole idea of propagation. One of the functions that we have as human beings is to procreate, is to have another generation follow us. And the land that we walk upon is ultimately always going to be for the future. So these are concepts that anybody who struggles with it, anybody who can't quite wrap their head around it, you just wonder, what are you not understanding there? And of course, people talk about investment and improvements on land and all kinds of leasehold improvement. That's a whole other issue besides land title.
You mentioned that if the issue of sovereignty comes up, the court basically stays away because otherwise it disqualifies them from even considering it. And one of the things that I've tried to get across to the council is that, well, they've said that some things have been done and therefore we can't undo them. I said, no, we claim we're sovereign. Therefore, all you have to do is have the Supreme Court review whatever it is that's been happening and say this has been unconstitutional, therefore you just
see that's just our own people not understanding. Because when people say that, what they mean is that, well, we've already paid taxes, so we can't unpay them now. No, that's not true. That's to say, like, slavery was legal, so it could never be made illegal. I mean, it's absurd to say that, because there are things that when you're in the best position, and I say this about land claims, I say this about a lot of issues, when we are in a better position to not only create a better legal argument, but also be in a better position to solve those conflicts without litigation, but to solve them politically. That's the whole thing. I mean, take for example, when the Seneca said, "Look, we're not going to pay the state anymore because that termed out," and the state said, and Niagara Falls mayor and everybody said, "Well, we're going to have to go to arbitration." And the Seneca Nation's position is, "No, we don't. This doesn't have to be reviewed by some sort of judicial board, whether it's arbitration or a court, or anything, because everybody says, oh, well, I guess this will get resolved in court." No, it won't. This will not get resolved in court. And the reason is because we aren't subject to your courts over this stuff. The language was clear. We entered in an agreement, and we fulfilled the obligation of the agreement. But anything we do going forward is a political resolution. It is either between two sovereigns or a sovereign and a quasi-sovereign, because that's all I would call the states, because the states are subject to the jurisdiction of the federal government. And when you look at something like gaming, for instance, the entire position that the state can take on gaming is afforded to them through a federal piece of legislation. It's not their inherent sovereignty. In fact, New York State, when they first engaged in compact negotiations, they couldn't legally do gaming themselves, which is kind of absurd. So no, so when I say that a court has to, they have to stay away from issues of sovereignty because they can't rule. They can't rule on something that's outside of their constitutional bounds. So the first time you suggest that if this issue isn't firmly and well established as something that's within the Constitution, then it can't be resolved by I would say that it not only can't be resolved by a federal court, it can't be resolved by by the Hague or the UN or anybody else, because we still haven't given them those entities that authority either. That's where, when you take something outside of a court where you're trying to ascertain whether something is criminal or not criminal, or legal or not legal, once you realize that there's no legal foundation to make that judgment, that's where it has to be through diplomacy. And that should not be something and that anybody, not Seneca Nation, not Mohawk Nation, not anybody, we should not be afraid of that. We should hone our diplomatic skills so we take more of these issues outside of the courts. And we should have had, I was glad and honored to be asked to testify in this hearing for Sean. But there were no Seneca Nation officials there. And I'm not saying they were asked. They probably were asked. But I think there's also this apprehension that the people who are elected into positions or appointed into positions through, through traditional processes or otherwise, they don't want to enter into a court and feel like they've been beaten. And so, but that's not the view that you need to take. I think to go into a court and maybe even flirt with this, with the very real possibility, what do they say? You are, what's the expression when the court gets mad at you and they say that you're
held under contempt?
Yeah. We're going to find you in contempt of this court. Well, I think it's perfectly reasonable to say, well, I have contempt for this court because what this court is doing is wrong. And so, and we have to have bold enough people to say, no, I'm not in here. And as an expert witness, I didn't go in there subject to that court. I went there to educate.
Right. I've argued the other point where you can't hold me under contempt because to have contempt, you got to have respect to start off with.
Exactly. Okay. Yeah. I mean, I'm not just displaying contempt. I'm just saying that you have not earned my respect. And I think that's the position. So, look, I mean, I know we're running a little bit out of time here. So I want to, first off, congratulate Sean Snyder. I mean, you're not $1.29 million richer, but you certainly have less debt than you had 2 weeks ago because this thing was hanging over his head.
His credit score went up a little bit.
Yeah, I would think. His credit score probably went up, but no. And I'm hoping this thing pans out well for ERW and their company because it seems like it's the same findings of fact. I don't know how it won't rule that way, but see, even and this is why I think it's important that people understand. And I'm actually surprised that nobody thought that this wasn't newsworthy. Mm-hmm. I mean, somebody should have ran to Channel 2 or WBFO, and of course, I don't mind being the one talking about it here on my show, but this was a big deal. It was a big deal because when you consider that there was a guy down in Brooklyn trying to change state law, and you realize that this judge is saying, no, you guys don't have that authority. I mean, she's essentially saying that you don't have the authority. I mean, and if you, again, looking at the excerpt from Atia that I read, how can they even suggest when they want to call that a landmark decision authorizing them, which it isn't, and not acknowledge how much that ruling that they think they won limits them? I mean, it's kind of absurd.
I just think their whole job is just trying to find ways to be a money grab. I mean,
well, it's money, but it's also power and control, and it's about oppression. I mean, we hear this all the time. And this goes right to Andrew Cuomo, with the way he was trying to negotiate things over gaming and everything else. They feel like they have to keep their foot on us. I mean, I go back to remember I was talking about Killers of the Flower Moon, the Osage murders. Yeah. Mm-hmm. When those Osage became rich because oil was found under lands and they had all those mineral rights, there were people in federal government who were saying, "What are we going to do about this? We can't have these native people with this kind of wealth." They were troubled by instead of saying, "Hey, these guys are independent now." No, they were troubled. In fact, so they create entire policies and bodies of institutions that would limit their own control of their own illegally try to inhibit the control of their own money.
I wonder if that's the foundation for that old Warner Brothers cartoon where they had the rich Indian Joe, I think his name was. He had the big mansion. He had the waterfalls in the house. And do you remember that one or no?
No, I don't remember that one.
I had to look for that. See,
maybe we can post it up on the webpage.
I'll look for that. He was all rich and he had everything was super fancy, but it was all native stuff. He had a teepee in the house.
One of the things that I've talked with people about, and especially council members, is that they have to take a look at the fact that the state legislature was trying to literally tax us. And the fact that it got defeated in Rules Committee, means that it's still coming. because it didn't get defeated in legislation; it got defeated in Rules Committee. So they'll just rewrite it.
Well, and it didn't. This didn't just get written. This is a piece of legislation that's been lying around. It's
Yes.
been kicked around for years. And this is. I mean, consider the fact that the Atia case was a ruling based on Mario Cuomo's the laws that he signed into law that would prohibit New York State wholesalers from selling us product without stamps on it. That was Mario Cuomo. I think Atia was ruled in 1992 or something, 91. And it wouldn't be until I think 2008 or 2010 that and it was, I think it was while Patterson was the governor, it was before Andrew Cuomo, that they would finally shut down New York State wholesalers from dealing with us. I mean, so it took that long. I mean, these guys stay at this, and frankly, the work that they do to make to try to make these things be implementable is shoddy at best. And again, if we wait until we're under the gun, and that's why I'm saying the work that we need to do is to educate even Martin Golden down in Brooklyn. And yeah, I might kick him around a little bit as I do it, but I think people have to understand what's at play here. The fact that thing died in Rules Committee, and then a couple of weeks later, or really a week later, Sean wins his petition, to cancel $1.9 or $1.29 million worth of fines. I mean, somebody's got to connect those dots for those very politicians, and you know what, we need leadership, and I don't mean just Seneca Nation. I think we need people to step up in leadership roles to make sure that this stuff does not go unnoticed. And and I just feel strongly about that. All right, what do we got here? Is this the one little, two little?
Little three little engines. 4 little, 5 little, 6 little engines. Sorry, that one was a half-breed.
Oh man, you didn't get Injun Joe, but you got Bugs Bunny shooting from the fort, and sorry, that one's a half. No, keep in mind he was scribing the wall as he was killing Indians, and when he shot that one, he said, "Oh, that's a half," and so he erased half the mark. I mean, it's oh man, you unbelievable. All right, guys, that pretty much wraps it up. Hey, I'm going to New York this week. In fact, I got Buffy St. Marie as my guest on my show on Thursday. So if you want to tune in and hear a little bit of Buffy St. Marie, then by all means do that. Maybe on Friday we'll play some of her music. She's performing in New York at the Summer Stage in Central Park on Sunday, the 9th, between 6 and 10 p.m. with a Tribe Called Red and Iske. So by all means, check it out if you're in New York City, or if you want to go there, stroll over to Central Park. Hey, thanks for listening, and we'll keep at it. Yowie.
Yeah.